have a wealth of experience in bankruptcy law. We're going to talk a little bit about conflicts in the circuits, but we're also going to talk about things that are topical. We are trying not to repeat all the stuff that you've heard thus far in the conference, because just about every topic's been covered. To my immediate left is Judge Dennis Dow. Judge Dow is from the Western District of Missouri in Kansas City. He was appointed in November of 2003. Before that, he was a partner with Shook Hardy Bacon. He is a member of the Executive Committee of the ABI. He is a prolific author on bankruptcy scholarship. To his left is Judge Robert Gerber from the Southern District of New York, who was appointed in 2000. He has presided over cases like Ames Department Stores, Adelphia, Lyondell Chemical, DBSD North America, and General Motors. He is also a prolific author. He's an adjunct professor of law at Columbia University School of Law, and he is a fellow and a member of the board of the American College of Bankruptcy. To his left is Judge Jeffery Hopkins from the Southern District of Ohio in Cincinnati. He was appointed in 1996. He was formerly with Squire Sanders and Dempsey, and he was formerly an assistant U.S. attorney in the Southern District of Ohio, and he's also an adjunct faculty member at UC. He's a fellow of the American College of Bankruptcy and an ABI board member. And last but certainly not least, a judge who calls himself the outlier because he's over there on the far left, Judge C. Ray Mullins from the Northern District of Georgia. He was appointed in 2000, formerly with the firm of Kilpatrick Stockton. He was a trustee also on the panel in Georgia from 1995 to 2000. He is presently president of the National Conference of Bankruptcy Judges, a fellow of the American College of Bankruptcy, and also an ABI director. So with that, I wanted to start with you, Judge Gerber. We've heard a lot about the Stern case through this conference and over the last year. But what really is the aftermath of Stern? And is there a conflict in the circuits? Do we have the 6th in Waldman, the 7th in Ortiz, the 9th maybe in Bellingham Insurance? Is there a conflict or is there just a mess?
I think I'd be inclined to say it's just a mess at this point, Trish, but let me amplify on that a little bit. I see, as I look around the crowd, that I know a lot of you, and I'm sure I don't need to start with Dada when it comes to talking about Stern versus Marshall. So rather than talking about what it held, let me talk about where I think the action is now, and talk about that Waldman decision that you had mentioned, Trish, because it certainly does cause us to scratch our heads in some ways, and to wonder about what its implications may be. You know, when we started our work on this panel, I was going to say that the worst of the earthquake was over, and that we were settling down and learning to live with the implications of Stern versus Marshall, and getting a better handle on what we could do and not do consistent with the requirements of the Constitution. And I was just going to talk about where the action is on the issues around the edges. Well, I think the earthquake is pretty much over, but there has been the aftershock. And that, of course, is the Waldman decision you were talking about, which has the potential to be pretty significant in the 6th Circuit and in any other circuits that follow the Waldman decision, though I'm not sure that other circuits will. So I'm going to talk about what I see as the open issues, and then, of course, I have to talk about Waldman so we can see where it goes. It could have an effect, certainly on the bankruptcy courts, but even more importantly on other elements of our judicial system. Most significantly, in my view, the power of our magistrates to do magistrate judges to do so much of the work that they do, and our ability to have federal courts enforce arbitration awards, which is important to our litigants being able to get their issues litigated efficiently and at minimal cost to themselves. First, just a minute on narrow versus broad. One level of uncertainty we've had from the start has been whether the Supreme Court really meant it when it said, in one way or another, 3 times in that decision, that its holding was a narrow one, and that it wouldn't materially change the division of labor in the federal courts and in the bankruptcy system in the one hand and the district courts on the other. I think that's still the case, and the majority of the cases are that way. But then we'll have to come back to Waldman and see whether that's a change or not. It's still very clear that in the bankruptcy courts, where we need to get our creditors' issues decided, and in the district courts, who would otherwise have all of this work dumped upon them, there is an overwhelming trend, I think it's fair to say, to hold that the Supreme Court meant it when it said that it was narrow. The more difficult issue is whether, with the circuit courts, who tend to be a little more removed from the firing line, whether that trend will continue. And all I can say on that is stay tuned. So, where do I now see the issues? Well, I think the silly issues are gone. We no longer see contentions that we can't fully decide the stuff we need to do incident to our in rem jurisdiction. And we can approve settlements in cases on our watch, even if we couldn't decide the underlying issues. And we can decide issues necessary to issue confirmation orders and the like. So, in my view, the real issues are in a different area, and in particular, about federal claims that have the purpose or effect of implementing federal bankruptcy policy, but which involve in one form or another a defendant, if it loses, writing out a check to the estate. So you have federal claims on the one hand, but they have the effect of bringing money into the estate on the other. So what am I talking about? I'm talking about 542 turnover actions, 547 preference actions, fraudulent transfers under 544 and 548, and unauthorized post-petition transfers under 549. And I think there's a spectrum of difficulty as we deal with that, starting with 549s, which I see as pretty easy, and then 542s, which I see as almost as easy, and then 547s, which I see as being on the edge, and then 548s, where you have a fair number of cases that have held that we shouldn't be acting, and 544s, where if you're going to make the distinction, our authority is even more debatable. All of these involve rights created under federal law. All are therefore distinguishable from Stern versus Marshall on that basis. But they invoke to different degrees our in rem jurisdiction. When you have stuff that was within our in rem jurisdiction and removed, as we do in a 549, I think that's pretty easy to say that we still have the constitutional power to undo the damage. If you have a turnover action, you're talking about property of the estate that just doesn't happen to be in the possession of the estate. And therefore, it would seem to me that getting it back is no big deal. If you're talking about collecting on a promissory note, well, you want green money, but the note is already property of the estate. And therefore, you can make a respectable or better than respectable argument that you're just changing the form of the asset from a promissory note on the one hand to green money that you can hand out to your creditors on the other. And I would submit that, especially since it doesn't change the debtor's balance sheet, is also within the constitutional power of the court to hear, although of course I'll keep an open mind to decide that on full brief. And of course, everything I'm saying here is, unless I've actually written on the subject, stuff that is really just for you to think about to help us judges do our jobs, because you do want to be comfortable that we're going to look at these issues. So I think that is where the action is going to be going forward. The Ninth Circuit recognized the uncertainty of bankruptcy judges' constitutional authority in the 548 area and invited supplemental submission of briefs by amicus in the Bellingham case, to decide the issue as to whether we can or cannot, consistent with our constitutional constraints, decide fraudulent conveyance actions. A lot, I think more than 20 amicus briefs were filed on that. But the court hasn't ruled, and I don't know whether it hasn't ruled because of the burdens on that court or because they thought the issues are hard. I think that will give us, though, a lot of guidance when it comes to it. Now, I want to jump away from the other things that I see as cutting-edge issues, at least to talk about Waldman, because it does have the potential of upsetting the kinds of assumptions that we've been proceeding under. There, the Sixth Circuit held effectively, though I suggest to you that maybe it didn't need to, that a non-debtor defendant that was being sued by a debtor in a non-core matter didn't validly consent when the defendant admitted that the matter was core, and then that even though, because the bankruptcy court thought it had everybody's consent and decided the underlying issues, the consent wasn't valid anyway. And if extended to its logical conclusion, that would mean that even when parties consent, both sides, fair and square, consent to determination by a bankruptcy judge, that consent doesn't count. It would also at least suggest the issue that when people do the same thing to an adjudication by an Article I magistrate judge, even if the magistrate judge holds a jury trial with everybody's consent, that kind of judgment doesn't stand up either. And then it's got to cause you to wonder whether it also applies in arbitration proceedings, which ultimately are based on a consent, on a contract to agree to arbitrate. And we in the federal courts enforce those judgments, or enforce those awards, even though the facts have been determined by not only a non-Article III court, but a decision maker who isn't fully bound by the law. I just suggest to you that issue raises questions in my mind for a couple of reasons. Although I don't think I'm going to have time to talk about the pros and cons of each of the arguments. Things that you guys can think about when you're doing that are, one, the Sixth Circuit failed, relied on Stern, mentioned Grand Financiera, though, but it failed to mention a third Supreme Court decision called Klein versus Kaplan, a decision by Felix Frankfurter, a guy who was hardly a judicial activist, that fully recognized the ability of parties to consent to the summary jurisdiction of the bankruptcy court back when we had the old Bankruptcy Act. It's a little hard for me to reconcile the Waldman decision with Klein versus Kaplan, although I guess it's possible if the Sixth Circuit had talked about it, it might have had some reason for thinking it was distinguishable. I'm not going to prejudge that issue, but I'd suggest that you think about it. I would also suggest that you think about whether they really needed to reach the issue at all, because it wasn't a consent. It was merely an admission that the action was core. And I think a lot of us would agree that a consent has to be unequivocal and it's got to be uncoerced. But once you have that, I would think you're on different terrain than if you have not done any more than to agree that the matter is core. Trish, I don't know exactly if I hit the 15 minutes I was going to take, but I think I'd rather let everybody else talk, and if I have time at the end, I'll come back to this.
You are exactly on the dime, on exactly 15 minutes.
One comment though, Trish, before we go, I can't just point out, there was an article in the Cincinnati Enquirer the other day. The Ninth Circuit had been supplanted by the Sixth as the court most reversed by the Supreme Court.
That's a distinction. Okay, well, we're going to move to Judge Mullins, and Judge Mullins is going to talk a little bit about a consumer issue, and that is the issue of surcharging exemptions. And there's a split now between the First and the Ninth Circuit and the Tenth Circuit on the other side with respect to whether you can surcharge exemptions. And when we prepared for the panel, I said to Judge Mullins, well, first of all, where in the Bankruptcy Code does it say you can do that? Is it in 522C? Is it 522K? Where's the section? And you couldn't really find a section, perhaps 105. It's a section that authorizes surcharging exemptions. But Judge, can you talk a little bit about that?
Yes, and a number to 105. No, this area is dealing basically with creditor misconduct pre-petition and what a trustee can do. And again, it causes a lot of consternation for trustees because, as we know, when they get into these cases, most of them don't have a lot of assets and they're getting $60 a case. And so how much investigation can they do and how much work can you expect them to do when they find this kind of conduct? And so, and that's where it gets into. And so it gets into one of, I'm sure that my colleagues hear the same thing in different forms. When I hear this, you know, and I ask the same question that you asked, Trish, usually the response I get is that you're a court of equity. So, which I always find very helpful. But anyway, let me talk about a couple of cases. The first one that kicked it off was 2004, the Ninth Circuit had Latman. And a simple, straightforward set of circumstances that will become, when you look at all the cases, a very similar set of circumstances. So you got as a debtor to file Chapter 13, and I guess they got fatigued after 4 months and 13. They took a time out and dismissed their case. And I guess the car and the boat that was in the driveway just miraculously, the day after they dismissed it, somebody made an offer to buy it. So they sold it and then decided 2 days later that they would need Chapter 7 relief. So obviously the sale proceeds weren't on the schedules in the statement of financial affairs. So the case comes in, the trustee does the investigation, trustee finds out about the funds subsequently. So again, the clock is ticking, as trustees know, on motions under 727 to bar discharge. You got basically 60 days after the meeting of creditors. So trustee files a adversary proceeding to bar the discharge. That's granted on a summary judgment. Case rocks along, trustee discovers some other assets and subsequently seeks a surcharge against the debtor's wild card exemption. The debtor has wild card exemption that would cover another vehicle and some jewelry. And so the court grants it, the bankruptcy court granted it. The debtor appealed to the district court affirms on all grounds, gets to the Court of Appeals. There basically the debtor's raising 3 issues on the ability of bankruptcy court to authorize surcharge of exempt property. 1, election of remedies, 2, res judicata, and 3, whether that exceeds the power of the court to use 105 in such a fashion. And basically, the election of remedies, basically debtor argued that because the trustee first chose to bring a 727 action and most of the facts come out of the same circumstances, that they were barred from bringing the subsequent surcharge motion. The court shot that down and noted that basically there are 3 elements to election of remedies. 1, 2 or more remedies must exist at the time of the election. Second, the remedies must be repugnant or inconsistent with each other. And 3, the party bound must affirmatively elect. And but the court looked at it and decided, the Court of Appeals looked at it and said, basically, it took the second branch and said they're not repugnant and inconsistent because they serve different purposes. The court argued that or held that the barring of discharge was like a punitive measure, was meant to punish the debtor, whereas the surcharge remedy was meant to take care of creditors that would, if you didn't rectify it, the debtor would be taking more exemptions they would be entitled to, and that will be taking it basically out of the hide of creditors. So,
Isn't it really like to take the cost, and when there's a discharge objection, there's no money that comes into the estate and debtors penalized. But who really gets penalized by this? It's the creditors who bear the cost of the trustees bringing the action, objecting to discharge, and it's all caused by the debtor's misconduct.
right, yeah, and that's right, and that's what and so that's why some of the trustees argue that you should be able to surcharge, because you've taken care of the debtor's misconduct and by penalizing them, but what are you doing to the estate? Because if you don't surcharge, what they're going to end up doing is, you got to remember, they exempt a certain property, and under the bankruptcy code, if there's no objection by party in interest, that property is exempt. And so if the trustee doesn't find out about some of that until much later, it's going to be bound by it. So the theory is, under a surcharge, this is the only way that you can take care of creditors and make sure there's not abuse of the court's process. And so they held that you could do that under the equitable powers of the court.
Ray, maybe you're going to get to this, but would there be some other remedies, like, for example, could you get a judgment against the debtor and then execute on it? If so, could you go after the exempt property there, or does 522 prevent you from doing that?
I don't know if it prevents you from doing it, Dennis. It's certainly, I mean, when I look at these cases, it's the distinctions that they purport, the two different views. If you look at it real close, it's like peeling the grape very thinly. It really leaves some overlap, because, for instance, saying that you bar the discharge, you're only punishing the debtor, but yet you come back in and surcharge, you're benefiting the state. But by the same token, if you haven't objected to the exemptions, and otherwise the debtor gets a fresh start and gets those exemptions, now you're coming back in there, isn't that really another form of punishment? So you get these labels on there, but the impact, I don't know if it's as black and white as the court seemed to indicate it is.
I know this is also in the case that you may be talking about it, but if you got a turnover order and the debtor doesn't comply, then the debtor is in contempt. Could you utilize the surcharge as a contempt remedy?
Yeah, and some of them, some of the cases do. That's where sometimes the action is brought is, first a turnover, and then when it fails, then contempt and surcharge. So they kind of load up on the remedies and put them in the sequence like that. So, and with regard to the last, where it exceeds the power of the court under 105, again, the notion is it prevents a fraud on the court and the fraud on the creditor. So the Ninth Circuit at least decided that to protect the system, they would allow the surcharge. So then you move 4 years later, you get in the 10th Circuit, a case called Scrivener, and similar circumstances. These are kind of facts that you can't really make up. The debtor has an interest in a local TV show. The TV show's name is Cheaters.
Maybe it's a Scrivener's error.
Yeah, that's right. Oh, good trick. But anyway, so there's some income in, and the interest the trustee tries to get, and so files a motion for turnover and compel a turnover and so forth, and then it moves into barring a discharge, which they get, and then same set of circumstances, you try to get a surcharge of the exemption. Where the 10th Circuit focused on is basically what you started with in your introduction, Chris. They looked at, Trish, they looked at it and tried to look at 105, tried to look at all the other sections that were involved, and they couldn't find a remedy of surcharge. You go to 704, which gives the trustee a lot of remedies, and then you go to 522, et cetera, but there was nowhere in there where there was a surcharge, and basically the 10th Circuit held that the court wasn't at liberty to grant more or less than the clear language of the code, and if it's not in the code, you can't make it up. You can't make up a remedy. And they even noted that even in circumstances where it appeared that absent a rule like surcharge, that a debtor could literally get away with improper conduct and could hurt the estate, but notwithstanding that, the argument goes, you still can't make it up. It's got to be somewhere. You got to find it in the code. And if the code has specific provisions to address the conduct, and and it's absent in their surcharge, then if the Congress gave you certain remedies and they don't mention surcharge, then you can't put it in. And so they basically went on the literal language of the code and the ability that 105 has to be restricted to fulfill other provisions of the code. And so they were the first circuit that said you can't do a surcharge. And then the last one actually was an interesting one that was just issued in August a few months ago. And it was interesting for a lot of reasons. It was the First Circuit case of one of Joan Feeney's cases. It was just a marital home. The debtor sold for $250,000 before the bankruptcy. There was a divorce, and he claimed that all the proceeds went to his ex-wife. But then I guess at the examination trustee, something spurred his memory, and he realized he got $25,000, but he forgot about it. So of course the trustee moves to for denial of discharge, which was granted, and then again the surcharge comes up. The interesting thing about this case is the author of the opinion was retired Justice David Souter, who was sitting by designation, and he basically looked at 105, and he looked at the language about where the court sua sponte could take action to protect the process of the court, and that his reading of that was pretty unlimited in broad powers. And he looked at it and said, well, if the court can do that sua sponte, it would be hard-pressed to come up with an argument why a trustee trying to protect the bankruptcy process and protect creditors couldn't do the same thing through a surcharge, and found that if you had an egregious conduct like this that couldn't be addressed to protect creditors, what else could 105 be? And if you couldn't do it there, then 105 wouldn't have very much meaning. And so he basically relied on the Ninth Circuit and allowed the surcharge. And at the end of the opinion, it's a very short opinion, he points out that the Supreme Court hasn't dealt with this yet, but they touched on something similar in the Rama, and the Rama has created a lot of controversy. So it's going to be interesting. Again, this was just an August decision. I'd be real curious if some of the trustees, like the 7 trustees, somebody doesn't try to get up on this using that and see if they can get up and split. That you have a clear split now, sir.
But it does seem to me, though, that Marama did say that one appropriate use of Section 105 is to deal with an abusive process.
Exactly.
And this seems like an abusive process.
And that's what Souter was saying in his opinion. And Malley versus Aiken, this is clearly an abusive process, and if you can't use 105 to cure it, what good is it?
Okay, Judge Hopkins, let's move to you.
On the substantive side, we haven't seen much, but Judge Gerber did publish a decision recently in a case where he's essentially said that it's a basic right to be able to credit it. And so you're going to have to overcome it now with cause on 363K. And one has to really search to find out what cause is going to be. How do you define cause? Well, bad faith could be one. We just talked about Marama. And in Marama, a Chapter 13 case, which has found application in Chapter 11 cases as well, the court sort of defines bad faith, and it says conduct that is bad faith is atypical or extraordinary. Now, I don't know how you get there from here, but certainly it's going to be a fact-driven determination that lower courts are going to have to make. One can also look at the designation statute 1126E, where creditors vote in a Chapter 11 plan can be designated because it's not having been made in good faith. That's
So Judge, a creditor or competitor comes into a bankruptcy, buys the debt in an attempt to effect a loan to own, and is that a situation where there could be cause for eliminating credit bidding?
You know, I think it goes to the heart of what the secured lender's rights are. And in researching this, I looked at the opinion from Philadelphia newspapers, and Judge Ambrose, no other authority than that. He's a terrific bankruptcy lawyer during his day as a practitioner. In his dissent, rigorous dissent cited by the Supreme Court, and Radlax had this to say: although some may argue that the credit bidding chills cash bidding, that argument underwhelms. Credit bidding chills cash bidding no more than a deep-pocketed cash bidder would chill less well-capitalized cash bidders. Having the ability to pay a certain price does not necessarily mean there is a willingness to pay that price. So I think that when you're talking about a secured creditor who's come in either by way of buying the lien position, I'm not sure that that's going to be enough. I think it's really going to be fact-driven, and the totality of circumstances is going to carry the day. I did find a case, I entered a search term, bad faith and secured creditor, and there was a case recently by Randy Haynes, and he had this to say about a secured lender who had was exercising their rights. He said the vote was for an enlightened self-interest consistent with both a voter's and a proponent's capacities in bankruptcy. In other words, this was a designation case under 1123, sort of 1126E, borrowing that analogy. But I think it really goes to the heart of a secured creditor's position, so I'm not sure that that's enough. But I don't know, Judge Gerber or others?
Well, I was going to agree with everything you said, Jeff. I was going to say that I think that we can bet, as sure as we know the sun's going to come up tomorrow morning, that people are going to argue that they should get 363K relief because it's going to chill bidding. And it seems that we don't want to prejudge when we're going to decide that we should invoke the exception or not, but I think it's fair to assume that anybody who wants to give us what we need to work with on that had better put up some evidence by an expert like a broker or an investment banker who can explain to us how, under the facts of that case, as Judge Hopkins just mentioned, it will chill bidding. My sense is if the collateral is worth way more than the amount of the secured debt, the bidders of the world will understand that, and they will bid what they think it's worth or what they think they need to get the property, and it's probably not going to be much of a chilling affair. I think if it's way below, then if people are going to bid at all, when they know how much the secured debt is, that they're going to be doing it for reasons of their own, and that again, it's not likely to chill. I think that where it may be most significant is where the value of the collateral and the price at which you expect the bids to come in are pretty close. And a thing like the head start of the secured creditor may have an effect. But I sure would want to hear evidence on that. I wouldn't want to do it out of my belly.
Okay, but I don't think anybody has actually answered Trish's question, though. So, and I'm not going to either, but I'm just going to suggest that. But I'm just going to suggest that I think that a sort of matrix that some of the courts do use on this question of good faith in voting, and that maybe is applicable to some of the designation cases, and that could be applied here by analogy, especially if the 363 sale is other than under a plan and 1126 would technically apply, is that if the creditor is acting in a capacity to enhance an interest other than its interest as a creditor, that is the thing that gets you in trouble, and that is the thing that invites additional scrutiny, and that's why the competitor situation probably implicates that, and so it gets closer to the line if it doesn't go over it. I think that's a factor.
Yeah, what's interesting in the designation cases under 1126E, you see where the vote is to enhance your rights as a creditor, and if you're acting, I think, in that capacity, as you say, Dennis, I think you're perfectly fine. But also, if you want to block the acceptance of a plan, the courts have said that that's okay as well.
Well, the idea being creditors have the right to get paid back, but when they have other things on their agenda, you got to look at them more carefully.
I mean, I'm not sure what that would be. If you bought the lien out on the open market, maybe to take over the business.
Yeah, not that competitor.
Maybe that rises to the level.
Let's move over to Judge Dow and back to a quasi-business consumer issue. Individual Chapter 11s had lots of provisions into the Bankruptcy Code in 2005, and programs started then at the end of 2005 and have extended till now, 2012. It's amazing that the programs are still standing room only because the issues not only haven't been resolved, but are probably more complicated and have shifted and morphed over the 7-year period. So Judge Dow, do you want to talk a little bit about the absolute priority rule, the problems that still exist in the case law, where it was and how it's shifted to today?
Yeah, sure. The fun just never stops. I mean, BAPSIPA is the gift that just keeps on giving. So as Trish said, we're going to switch gears a little bit now and talk about a Chapter 11 issue, although it's an issue about individual Chapter 11, specifically the continued vitality or not of the absolute priority rule in those kinds of cases. And regardless of what your practice is, you ought to be interested in this, because if you're a consumer lawyer, I know some consumer lawyers, if they find debtors who they might otherwise put in Chapter 13, but they exceed the debt limits, they may consider individual Chapter 11. And business lawyers who maybe represent people who have very high incomes and complex business and financial structures may find it necessary to put them into an individual Chapter 11 case, so I think you need to know what's going on here. We need to talk briefly about, or do sort of just the very briefest review or reminder of the absolute priority rule, and then I'm going to talk about the various provisions which were added to BAPSIPA with respect to individual debtors, and then we're going to talk about how the cases evolved and the trend and sort of the current scorecard, and then we'll talk in detail about the arguments and rationale in each case of the two schools, because there are two schools of thought. You know, Yogi also said, when you come to a fork in the road, take it. And the courts have taken both forks in connection with this. All right, so we all know that there are two ways of trying to get a Chapter 11 plan confirmed, the so-called acceptance method and the cram-down method. Under the acceptance method, one of the things that you have to do is each class has either got to be unimpaired or it has to accept. And then in 1129B, when we go to the cram-down method, it says that notwithstanding the fact that you didn't satisfy that requirement, you can still get the plan confirmed if it is both fair and equitable, and it does not discriminate unfairly. And fair and equitable for a class of unsecured creditors includes the treatment that either the unsecured claims are getting paid in full, or no junior class of claims or interests either receives or retains any property under the plan on account of those junior interests. Well, what does that mean? Well, in a corporate case, it means the shareholders. The shareholders are junior to the unsecured creditors. They can't retain their rights if you're not paying the unsecured creditors in full, and that class is impaired and has rejected the plan. For individuals in business, it would mean their interest in the proprietorship. For individuals not in business, it means their interest in the property they own, at least the interest in non-exempt property. Even some of the courts that have taken the so-called narrow view of the absolute priority rule, well, the courts that have looked at this before BAPSIPA have said that the debtors can retain exempt property and still confirm a plan without complying with the absolute priority rule. And as I said, BAPSIPA made a number of changes to the code in Chapter 11 to sort of make it look more like Chapter 13. It's useful, I think, to at least briefly overview those. Section 1115, and this is one of the principal ones here, adds to property of the estate in a Chapter 11 case for individuals two items. One, property acquired by the debtor after the filing of the case, and two, post-petition earnings of the debtor. Both things that would not otherwise be included under 541. And it's interesting to note that this language is actually identical to Section 1306 of the code, which does the same thing in Chapter 13 cases. And the Fourth Circuit in Maharaj actually noted that and cited a Sixth Circuit case that interprets 1306. Just a little tidbit there for your cocktail parties. The disposable income requirement was also included. 1129A15 provides that if an unsecured creditor objects, the debtor must commit value equivalent to 5 years of projected disposable income as calculated under 1325B2, either 5 years or a longer period if the plan provides for a longer period of payments. Then 1123A8 says that the debtor has to commit at least enough income under the plan to effectuate the plan. 1127 now says for individuals that plans can be modified subsequent to confirmation even if they have been substantially consummated, which of course is different than the usual Chapter 11 plan. 1141D5 now says that in individual cases, the discharge does not occur until after all the plan payments are made. Ordinarily, you get a discharge when the plan's confirmed, but now the discharge is delayed until plan payment. And there's a new provision in 1128 that provides for a hardship discharge if they don't make all the payments, which is very similar to the Chapter 13 hardship discharge provision in 1328B. It's not identical. For some reason, there are 3 elements of a 1328 hardship discharge, but only 2 in a Chapter 11 hardship discharge. I don't know why they dropped one of them, but they did. And then the most significant one, the one we'll focus on, is the change to 1129B2B, which after the formulation of the absolute priority rule adds the language, except that in the case of an individual debtor, the debtor can retain property, quote, included in the estate under section 1115, close quote. And that is the key issue. What does that language mean? And there are 2 views that have been adopted. One is the so-called broad view, and it's called that because it's a broad view of the exception to the absolute priority rule requirement. And it would permit the debtors to retain not only those 2 things that are added under 1115, the post-petition property and post-petition earnings, but all other property that would come in under 541, pre-petition property that the debtor owned. The narrow view means that only the 2 items of property specified in 1115 may be retained. If the debtor retains anything else, then there is a problem, which prohibits confirmation of the plan. Well, as Trish said, the cases started to come out a couple of years after the statute was adopted, and the first 3 cases all took the so-called broad view. The Tegeter case out of Nebraska, which is Judge Saladino's, the Rodemeyer case by Judge Summers in Kansas, and then Judge Markell from Nevada weighed in the Shack case and included a very extensive discussion of the legislative history and the purpose of the absolute priority rule. But then the trend reversed itself. And since then, all of the other cases that have decided this question, with 2 exceptions, have taken the other view. So that's now clearly the majority view. There's a district court case that adopts the broad view out of Florida, and a BAP case, the Ninth Circuit BAP in Friedman, also adopts that view. But every other case has taken the other view, including the only circuit court case, which is the Maharaj case out of the 4th Circuit. So the current scorecard, I think, is there are 5 cases that adopt the broad view. There are 17 cases that adopt the narrow view. Now, your materials say 16, and that is because there is another case decided on November 9th by the Bankruptcy Court of the District of Puerto Rico called In Re Chin, which also adopts the narrow view. And it's not in your materials, so I'll give you the site. It's at 2012 Westlaw 546-3256. 2012 Westlaw 546-3256, Bankruptcy District of Puerto Rico, November the 9th of this year, and adopts that view. Now, they've come to these views in all different ways, and this is not unusual when we see this in BAPC interpretations. Some of the courts have found this language unambiguous and adopted the broad view. Other courts have found the language equally unambiguous and embraced the narrow view. Some courts find the language ambiguous and hold that the broad view best coincides with the apparent congressional intent of making Chapter 11 for individuals more like Chapter 13. And other courts have found the language ambiguous, but conclude that the narrow view is the interpretation that is most consistent with the language, context, and the purpose. So let's talk about the 2 views and what the arguments are. I think you'll find if you look at the cases that there are basically 3 issues that the courts are looking at, or 3 arguments. One is the question of statutory interpretation, the language used in the code, and application of the canons of interpretation and construction. The second is a question of sort of congressional intent. What do we think Congress was trying to do here? And third is a question of context and purpose. In terms of the courts that have adopted the broad view, their view of 1115 and 1129B2B is that when 1129B2B says included in the estate under 1115, since 1115 says that in addition to the property specified in 541, property of the estate includes these other 2 things, that 1115 includes everything. And therefore the language included in the estate under 1115 applies to all of those things. So there's a kind of incorporation by reference in 1115. So everything is included in the estate under 1115. Their second point is that if we adopt the narrow view, then the exception to the absolute priority rule for individuals is virtually meaningless. It's trivial, some courts have said. It has very little effect. And the third point is one of congressional intent. They say, well, look how much Congress has tried to make individual Chapter 11 look like Chapter 13. And we know that there is no absolute priority rule in Chapter 13. So looking at this language, considering the change, and deciding which of these views is the most sensible one, it must be the case that Congress intended to abrogate the absolute priority rule in individual Chapter 11 cases.
Judge, if Congress did intend that, how did the cases deal with the fact that one of the purposes for voting, if you don't have any absolute priority rule, and why it still exists in an individual case?
Well, I mean, that was the very first case that went the other way, Judge Tchaikovsky's case, in a decision in which the debtor's name is one that I can't pronounce, but it's cited in your materials. She made that point. She said that it kind of makes voting irrelevant. The unsecured creditors, if you're going to give them anything at all, you have to solicit their votes. Then they vote against the plan, and you say, "Oh, okay, sorry, we're going to confirm it anyway," and it may virtually make it meaningless. And that's one of the arguments on the other side. Before I go to those arguments, let me just make the point that Ralph Brubaker has a new article on this in one of the most recent editions of the Bankruptcy Law Letter. So if you're a debtor and you've got this problem and you want to see a good assessment of the arguments, and he's clearly advocating this view, the broad view, look at the October 2012 edition of the Bankruptcy Law Letter and look at his article in there. But following on Trish's point, in terms of the narrow view, first of all, the courts have said, in terms of included in the estate under 1115, well, it can only mean the two things that 1115 adds to the estate, because all the other stuff is already included in the estate under Section 541. It doesn't need to be re-included. And if you interpret it that way, 541 becomes virtually meaningless in Chapter 11. It's superfluous. You write it out. So, as Judge Bowie said in the Karlovich case, what he thinks they've done here is Congress giveth and Congress taketh away. Congress, first of all, includes this property in 1115 in property of the estate so that it has to be dealt with by the individual Chapter 11 debtor, but then it takes it out of the absolute priority rule. So it essentially leaves debtors precisely where they were before with regard to the absolute priority rule. If you want to look at a really interesting grammatical analysis of these phrases in 1129b2b2 and in 1115, look at the Arnold case, which is cited in your materials. I think the judge must have been an English major, because there is an analysis that goes on. It's fascinating and it's really extensive. It goes on and addressing the function of nouns and pronouns and transitive and intransitive verbs and the objects of transitive verbs and prepositional phrases. Gene, you'd love this case. And adopts the view that appropriate grammatical analysis is more consistent with the narrow view. In terms of responding to some of the arguments that the broad view courts make, with regard to the similarity to Chapter 13, the courts have said, well, look, if Congress wanted to just make it a Chapter 13, it could have eliminated or extended the debt limits for Chapter 13, but it did not do that. Another primary aspect of the cases on the narrow view is that if Congress really wanted to abrogate the absolute priority rule for individual debtors, it could surely have done it in a much less convoluted way. It could have done it very clearly by simply adding a tag at the beginning of 1129b2 which says, except in the case of an individual debtor. But it didn't really do that. The courts have also relied upon some old principles of statutory construction, one against implied repeal. There is a presumption against implied repeal. And so the argument is that if Congress had really intended to abrogate the rule, there would have been at least some reference in the legislative history to it. As a matter of fact, there was a very interesting discussion in the Maharaj case in the Fourth Circuit about, and this is something I learned when I reviewed this, apparently back in 1952, the Congress made changes to the bankruptcy code. The absolute priority rule is a judge-created doctrine, but the code was amended in 1952 to essentially repeal the absolute priority rule in some cases. The legislative history says the reason for it is because unless that was done, it would be almost impossible for certain debtors, like individuals, to confirm cases. Well, in 78, the code adopts the absolute priority rule across the board, and in 2005, these changes are made, and there's no reference in the legislative history. So that has persuaded some courts. And then the Supreme Court has also told us recently, even in some bankruptcy cases, that it's not going to assume that Congress makes a change to a long-standing practice in bankruptcy law unless it does so clearly, and it just really didn't do so here. And finally, there are policy reasons the court had looked at. What BAPC case would be complete without a reference to the fact that Congress intended to require debtors to pay as much as they could pay, right? And this is what actually Ralph Brubaker refers to as this canon of statutory construction, which is jam it to the debtor good and hard. So, and then finally, some courts just think that the absolute priority rule is a key component of the balance between creditors and debtors, balancing the debtor's ability to get a plan confirmed with the creditor's ability to have participated in the process in a meaningful way, and also to assure that they get value before the debtor gets paid.
So, Judge, if you accept the rule, the holding that there is an absolute priority rule, how does new value work?
Well, that's a good question. Yeah, I didn't touch on the new value thing. The new value corollary, of course, still presumably exists. I guess the Supreme Court has never really said that it does. It's just told us what has to be done sometimes, if it does. But assuming that it does, then presumably a debtor could try to provide new value. Now, the problem is, some of the courts have said in this context of individual Chapter 11s that the new value has got to come from somebody other than the debtor, which would mean a third party. And if you're not in one of those jurisdictions, then I'm not sure where the new value could come from, except if you're also in a jurisdiction which believes that the debtors can still retain exempt property, then the new value, I suppose, could be the debtor contributing the exempt property, or conceivably, the debtor could contribute the value of the PDI beyond the 5-year period, which the debtor would not otherwise be obligated to put in. Maybe that's new value. I don't know. But otherwise, clearly, it's going to be difficult. And some creditors, particularly large creditors, are going to have leverage, like a big deficiency claim on an unsecured claim, or a judgment creditor or something like that, and it will be very difficult. But the flip side, of course, as you pointed out, is that it almost makes negotiation irrelevant if you adopt the other view. The debtor doesn't have to negotiate because the vote can be ignored once it's given. It's a tough question.